There is a very famous case out of the United States Supreme Court that was decided, and it had to do with what was going on with Martin Luther King Jr. in Alabama. You may not have known that this case was about that. We have New York Times versus Sullivan, and this case was decided in 1964. Here's what happened. So the New York Times newspaper, you can kind of look up what a newspaper is, but they had a group of people that bought an advertisement. And in the advertisement, it went through how they were upset and they were criticizing the police in Montgomery, Alabama for their treatment of Martin Luther King Jr. and the civil rights protesters. So within this ad, they had inaccurately put in the number of times he had been arrested, as well as what songs were being sung. So some minor inaccuracies, but the police commissioner in Alabama was quite upset about it. So he sued for defamation. He wasn't mentioned in the advertisement, but he was upset. Up to the U.S. Supreme Court it goes, and the U.S. Supreme Court set out the standard that we use today when it comes to defamation cases involving a public figure. It's a two-part test, one or the other. And in order to establish that there's been defamation, you have to show that the defendant or the press, the publisher, knew the statement was false or was reckless in deciding to publish it without investigating. So if one or the other of those was present, you could go forward with a defamation suit. In this particular case, we had a public figure, yes, but we did not have that knowledge or reckless disregard element, either one of those pieces, and therefore, New York Times won the case.